character evidence of the victim. In some cases, the parties are also permitted to introduce character evidence of the alleged victim. Only it is important for us to note, only in homicide and criminal assault cases, when the defendant claims self-defense, and then this victim's character evidence could be introduced. So it is very important for us to know only in two types of cases. One is homicide case, another one is a criminal assault case, and also there are also one condition, that is the defendant claims self-defense. In these cases, under these circumstances, the victim's character evidence could be introduced. Why do we introduce the victim's character evidence? The purpose is to prove who was the first aggressor in this either homicide case or this criminal assault case. Because we know in this case the defendant claims self-defense. But according to criminal law, self-defense is not available to the first aggressor. So it is for the defendant, if the defendant wants to claim this self-defense, if he wants to use this defense successfully, he must prove the victim was the first aggressor. Because according to criminal law, if the defendant actually was the first aggressor, and then the defendant would not be able to claim the self-defense. So how could the defendant prove the victim was the first aggressor? And then one way to show that was to show the victim's character, to introduce the victim's character evidence. So in this, suppose in this case the defendant is on trial for criminal assault, and then he claims self-defense. The defendant may introduce character evidence to show the victim was a violent person. So because the victim was a violent person, so it was more likely the victim actually struck the first blow. That was the reason why the defendant wants to introduce the victim's character evidence. Once again, the reason for introducing this character evidence is to prove who was the first aggressor. If the defendant wants to introduce this evidence of the victim's character, of course, the defendant wants to show the victim was the first aggressor, because we know to be successful in claiming this self-defense, the defendant must prove the victim was the first aggressor. It is important for us to know, even though in this in evidence law, we permit the defendant to introduce the victim's character evidence, but once the defendant offers victim's character evidence, the prosecution may also offer victim's character evidence. It is important for us to know the prosecution may offer two types of evidence. One type of the evidence is to defend the victim's good character. For example, if the prosecution, if the defendant would say in this case the victim was a violent person, and then to defend the victim's good character, the prosecution may introduce evidence to show the victim actually was a peaceable person. The victim was not a violent person. In addition to that, the prosecution may also introduce the defendant's bad character evidence. The prosecution may also introduce evidence to show the defendant actually was a violent person. So that is really, because we understand the issue here is who was the first aggressor. So for the jury to make a determination on that issue, it is just fair if the defendant would introduce evidence to show the victim was a violent person. It is just fair for the prosecution to introduce evidence to show the defendant was actually a violent person. So based on this presentation of the evidence, the jury may decide who actually could be the one who actually struck the first blow. So that is really the two types of evidence the prosecution may introduce. Now let's look at this case scenario, and suppose we have this homicide case, and then the defendant would introduce the evidence to show the victim had a reputation of being a violent person. The defendant could do this because we know this is a homicide case and the defendant claims self-defense. So to prove the victim was the first aggressor, he could introduce evidence to show the victim had a reputation of being a violent person. But after the defendant introduces this evidence, the prosecution may introduce the evidence to show the victim had a reputation of being a peaceable person. That is a defense of the victim's character. The prosecution may also introduce evidence to show the defendant has a reputation of being a violent person. So the prosecution actually could introduce both types of evidence. Once the defendant would introduce evidence attacking the victim's character. Another issue related to the victim's character is rape shield laws. This is also involves the victim's character. We are talking about these sexual assault cases. It is important for us to know at common law. In sexual assault cases, the defendant was permitted to introduce evidence of the victim's character. The defendant was permitted to introduce this kind of evidence. This evidence at common law was considered relevant for the issue of consent. Meaning is, we know if the defendant was on trial for this sexual assault, and the most often used defense was consent. Of course, if the defendant could prove he obtained consent from the victim, of course, we know this sexual assault case, the prosecution could not succeed. So, because of this issue of proving consent at trial, the defendant may question about the victim's other sex partners or other sexual behavior. The issue of relevancy is this, and if say the defendant is on trial for this sexual assault, but defendant said I actually obtained this consent from the victim, and then if the defense could present evidence indicating the victim actually has many sex partners and very easily, and she would give consent to have a sex, and then the argument of the defendant would be because the victim would readily give consent to other people, and then in this situation she also gave consent to me. So that is the argument of a relevancy. Based on that, at common law, it was considered to question about this victim's other sex partners or other sexual behavior was relevant to the issue of proving consent. But we know this practice is also very damaging to this victim of this sexual assault, because you need to remember if this victim of this sexual assault would come to court, and then the and then the defense lawyer and then may ask her to tell the court in the open court, and she actually had sex with what other people, and then under what kind of circumstances, and she would give consent to have sex. That that is highly embarrassing. So many people say if you ask these rape victims to go through this, that is just a second victimization. Not only the victim was assaulted by the defendant, now in court you want to embarrass the victim once again. So based on this concern, in the 1990s, we had this rape shield laws introduced in all the jurisdictions, including the federal jurisdiction in the United States. So after we introduced these rape shield laws, the defendant is no longer permitted to examine the victims. Is no longer the defendant in sexual assault cases is no longer permitted to introduce the victim's character evidence. So now we can look at this rule 412 of this Federal Rules of Evidence. It says in these sex offense cases, the victim, above this victim, it is prohibited to introduce evidence to prove that a victim engaged in other sexual behavior. We know the defendant can no longer ask this victim to tell the court under what kind of circumstances, and she had what kind of sex partners and the circumstances under which and she had sex with them. It was not permitted for the defense to make this line of inquiry. And the defendant is also not permitted to offer evidence to prove the victim's sexual predisposition. The defendant cannot say this defendant actually talked in a very provocative way and maybe wearing this short skirts or something like that. So no sexual predisposition evidence is permitted either. But we do have two exceptions. One exception is if the defendant would say this someone other than the defendant was the source of the semen injury or other physical evidence, and then the defendant may introduce relevant evidence. To look at this example, we would understand what we mean by this rule. Suppose Alan is on trial for rape. The victim was Nancy. Alan claims that the person who sexually assaulted Nancy was Bill, not him. And then Alan would be permitted to introduce evidence showing Nancy's sexual relationship with Bill. This is one exception under which, even under this rape shield law, the defense may introduce evidence to show the victim's other sexual behavior. So this is one exception. This exception is very understandable. And then there's another exception, that is if the victim and the defendant, they had sexual relations before, and then the defendant may offer evidence of their past sexual behaviors to prove consent. Once again, we look at this example. Suppose Alan's on trial for rape. Nancy is the victim. Alan and Nancy at one time were boyfriend and girlfriend and had sexual relations. Alan in this kind of situation is permitted to introduce evidence of his sexual contacts with Nancy to prove consent. We know this exception is also reasonable. If we have this situation, a boyfriend, past boyfriend, girlfriend, suddenly the girl said she was raped, but if these two before they had this sexual contact, and then the defendant is permitted to introduce the evidence to show this time he also obtained consent from the victim. So that is another circumstances the evidence could be introduced. The exception, the last one, you do not have to worry about this one. This is just saying that if the evidence would be excluded, this item C, and then if that would be in violation of the defendant's constitutional right, you don't have to worry about this. You do need to remember the two exceptions we discussed previously.